And today we will focus on exactly what arbitrators are looking for. With that, I would like to introduce you the fantastic speakers on this panel and all co-organizers of this event. I have with me Dr. Ismail Selim. Welcome. Dr. Ismail is the director of the Cairo Regional Center for International Commercial Arbitration, Corsica. He is also the president of the International Federation of Commercial Arbitration Institutions, known as IFCAI, which collaborates between the institutions worldwide with respect to arbitration. He's the chairman of the Egypt branch of the Chartered Institute of Arbitrators, vice president of the African Arbitration Association, and of course holds many other key roles in the arbitration industry, being a contributor to the thought leadership in arbitration, but also further afield. Welcome, Dr. Ismail. Thank you for organizing this event and joining. Brad is also very well known in the region. He's a testified delay and quantum expert. He's a member of the Academy of Experts. Sits as an expert determinator, as an arbitrator. He's CEDA accredited mediator based in the GCC region. Saad holds a BSc in civil engineering and a master's in strategic project management and LLM in instructional.
I think we lost you.
Antonio, we lost you, yes.
Yes. Till Antonia come back, can we ask the participants who would like to listen to us in Arabic للمتحدثين أو الراغبين في سماع الندوة باللغة العربية؟ أعتقد
But I'm a partner between it. I'm focused on arbitration. I also
Antonia, I think we lost you for a while. So till Antonia come back, للمتحدثين باللغة العربية الراغبين في سماع الندوة باللغة العربية، في زرار أو يعني ممكن ندوس عليه اسمه interpretation. If you wanted to press on the interpretation, you will have هيبقى موجود English وعربي. للعربي I think تقدر تدوس على الشانل العربي وتستمع إلينا باللغة العربية. Sorry, Antonia was just telling them about the interpretation till you come back. So here you are, it's all yours.
Thank you. Thank you. Can you hear me now? Apologies for the connection issue.
Yes, yes.
Thank you. And yes, exactly. Thank you, Saad, for explaining the interpretation. So Saad is saying, I can see there's a button. I will click it myself now. Interpretation where you can choose between English and Arabic. So hopefully this will work for everyone. And again, thank you so much for all of the attendees who's joined so far. So with the introductions in place, I say we should kick off this fantastic session this evening. Another minor matter of housekeeping. You're all welcome to send questions via the Q&A button, either as we go along with the session or at the end. We will have time to discuss questions towards the end, but please feel free to share any comments or questions during the session as well, and we can try and address them as we go along. So before we talk about what it is that arbitrators want to see from counsel, experts, witnesses in an arbitration, we thought it may be useful to start with the recent changes to the arbitrator practice. The question is, especially in light of especially since there's significantly more arbitration in recent years, the role of the arbitrator has evolved. And there are various changes that now impact what an arbitrator may want. So before we get there, Dr. Ismail, could we start with you and the question, how has the role of the arbitrator evolved in recent years in light of various global developments?
Thank you very much, Antonia, for the question. Can you hear me well? I want to be sure that my connection is fine.
Yes,
Very
I can hear you very well.
So I will tackle two issues. The first issue is the determination to combat due process paranoia. And the meaning of due process paranoia is when an arbitrator or a tribunal is afraid to proceed because it is threatened by counsels ambushing the tribunal and threatening the tribunal that if their procedural requests, sometimes which may be unwarranted, are not complied with, the arbitral award will be set aside, and they would challenge the award at the stage of enforcement. So there is a trend to combat it and to reduce it. I will give an example since I'm managing an institution. I will give the example of the change in the wording and the language of the arbitration institutions rules. In the past, arbitration laws and institutional rules used to provide that each party should be given a full opportunity to present its case. Today, this language in most of the modern institutional rules have changed, and now the requirement is to merely grant a party a reasonable opportunity to present its case. So full versus reasonable opportunity to present its case. A reasonable opportunity means that each party is given an opportunity to understand and rebut the opponent's case, and to be allowed to present evidence and arguments supporting its own case. A tribunal also is advised, an arbitral tribunal, when serving, must be well informed of the local court decisions of the seat of arbitration and the possible places of enforcement in order to be well versed and well prepared when threatened with procedural objections, and so that the tribunal doesn't fall into the trap of procedural paranoia. The other global legal change pertains to corruption. So we find a lot of corruption allegations, warranted or unwarranted, that are raised during the arbitrations, and the arbitrators must take them very seriously. In the past, the approach, and the very famous case of Judge Lagergren, the famous Swedish arbitrator, in the ICC case number 1110 in 1963, where the arbitrator declined jurisdiction because he found that there was an issue of corruption, and he declined jurisdiction. Now this position is considered obsolete. An arbitral tribunal, if an allegation of corruption is raised by the parties, it has to decide upon it. It has jurisdiction to decide upon it. It is arbitrable, and the arbitral tribunal's approach would be either to dismiss it or to uphold it and decide accordingly. Also, at the stage of enforcement or the stage of annulment, the post-arbitral proceedings, now the courts, by way of example, French courts, tend to scrutinize the awards and the public policy defense when it is based on an allegation of corruption. So there is no revisit of the merits, but the allegation of corruption would bring a very thorough scrutinizing thereof by the court. And we have seen that there are very recent case court's decision, Kyrgyzstan case and the Gabon case, so these are awards issued by the French Court of Cassation in 2022, and the awards were respectively set aside or its enforcement was refused due to substantiated allegation of corruption or money laundering. Thank you.
Yeah, absolutely. I mean, this is sort of the backdrop to our discussion today, very helpfully set out, Dr. Ismail, because when we are talking about what arbitrators want, we need to at all times consider what arbitrators' role is, that they are working on delivering an enforceable award, and they need to take into account the legal backdrop, the various implications that you're mentioning. So that's vital for really the remainder of the discussion, and of course for our entire arbitration practice. Just briefly again, before we kind of dive deep into the issues, talking about some of the misconceptions. Necessarily, there are misconceptions between what arbitrators may want and what other parties, counsel, experts, etc., what priorities they may have within the arbitration process. So the aim of today's session is, of course, to demystify some of this to some extent, but just in general terms, some of the examples, for example, with respect to misconceptions about arbitrator expectations, relate to, for example, submissions, procedural correspondence. So what we see regularly is that counsel engage in very lengthy correspondence with the other side, often take tactical positions in correspondence. Similarly, in submissions, often parties or counsel spend very significant amount of time considering their particular tactical advantages, certain priorities that the counsel may have in that particular situation. But how do arbitrators look at all of this? So I also sit as arbitrator, and I'm always astutely aware of the perspective of an arbitrator when I act as counsel. And I think that's one of the aims again for today's session, is to really switch hats in this environment and really think about it from the perspective of the arbitrator, because an arbitrator, as Dr. Ismail has very eloquently put, needs to issue an enforceable award, needs to consider the legal backdrop, and therefore does not necessarily need to be engaged in the tactical games, in the procedural mechanics in the correspondence, or in very lengthy submissions that may not go to the particular point. We'll talk about submissions, etc. in a bit, but Dr. Ismail, do you have any additional thoughts on sort of these kind of general misconceptions between arbitrators and others involved in an arbitration?
Thank you very much, Antonia. So your question deals with merits issues and procedural issues at the same time. So regarding the merits, of course, I have served as counsel in the past, and I've regularly served as arbitrator while wearing the hat of the director of the center. So my perspective and I would expect from a counsel a convincing narrative. That is what an arbitrator would expect. The arbitrator is looking for a story, but of course it does not override that we are expecting very good pleadings, facts, evidence, law that establishes such facts. But we are looking for a convincing narrative. And we expect from counsel, or my advice to counsel is also to try to be neutral. So neutrality and impartiality is not only a matter of the arbitrators, but also the counsel. And I will tell you why. Because usually the counsel sympathizes, the counsel can fall in love with his or her case. There is a lot of sympathy with the client, and there are a lot of emotions. So this sometimes can let the counsel forget to properly evidence the case, and trying to portray its client as the poor and as the victim, and then to try to portray the opposing party as the villain and as the guilty. And if we exaggerate in this narrative, I think it's counterproductive, because at the end, an impartial arbitrator would expect to see facts that have been substantiated, evidence, and the applicable contractual or legal provision that would lead to an award in favor of the relevant claim. And at the end, an impartial tribunal will rule on a claim and will not classify the parties as one villain and one kind, and to rule exclusively for the kind party. So that's one issue. The second issue regarding procedurally, you have to know your arbitrator and his background or her background. If you have a president of a tribunal, and this profile is a profile that you sometimes find a lot, it's not always the legal counsel. Sometimes it's a very eminent professor of international law that has never served as counsel. So when this type of arbitrators, they get bombarded with a lot of letters that are very aggressive and get drained with this, for them it's very draining. It's very they really feel uncomfortable. So sometimes you need to show your muscle in some procedural correspondence, but do not exaggerate in doing them. And read your arbitrator, his background, whether he comes from a civil law background or a common law background. He is completely international and exposed, or he is a domestic arbitrator. So this, I think, will play a big role in how the council is going to proceed.
Yes, two really fantastic points. I mean, I absolutely, I couldn't agree more on neutrality. I mean, that is one of the key misconceptions, isn't it, between counsel and arbitrators? Because, as you say, counsel consider themselves innately not neutral, not independent, but pro-party, and they present the case in that way. But as you say, they have to convince an independent, neutral tribunal. So what better way than to, in fact, look at it from that perspective? And of course, also absolutely vital to know your tribunal, to know exactly who you're making submissions to. So yeah, could not agree more. Engineer Thad, turning to you, and again, before we get into sort of the meaty detail of these issues, what kind of general misconceptions do you see relating to expert evidence in particular? Again, we're looking at sort of the perspective of the tribunal as compared to the perspective of counsel, parties, experts with respect to expert evidence.
Thank you so much, Antonia. I think you touched upon things when you said like people are wearing sometimes different hats during time. So I will not speak too much about arbitration since Dr. Ismail here as an arbitrator, but sometimes I sit regularly as an arbitrator, and my main job is the expert. So in arbitration, you know that expert evidence is critical for helping the tribunal to understand the complex issue that actually require the specialization or specialized knowledge, which is going to be beyond of the knowledge of the average person. The common misconception, in my opinion, if you are an expert or coming from the evidence, first of all, the expert must always support the hiring party claim, which is totally wrong. There is a relevant misconception that the role of the expert is actually to advocate for the party that hired them, which is totally wrong. In reality, the primary duty of an expert is to assist the tribunal by providing an independent, unbiased opinions. This opinion should be based on their expertise. So the experts actually are expected to present their findings fairly to the tribunal, and even if this finding does not actually support the claim or the defense of the party that engaging them, the party can choose easily to just neglect this and not present this evidence to the tribunal and just hire somebody else or try to find, because it's a matter of opinion at the end of the day. The second one, I think, is that experts and even parties, sometimes the parties actually is the main people who think about this one, that the more complex evidence is actually more convincing. This is actually also a misunderstanding, that the more details in the complex report are more persuasive, I would say, to the tribunal. Arbitrators actually, because I sit in both sides, they would like to have like a very clear, concise, and well-structured report, actually showing them the evidences and directly address the issues in hand, because at the end of the day, he's not here to read this very complicated matter. He would like and help on the complex technical issue could actually help them to get better explanations and to make this difficult thing it's very easy and give them the key points. One of the other things as well is that sometimes the evaluation of all the experts would have the same level of credibility. So the credibility of the expert evidences in the eyes of arbitrators is not actually the same, because it can be varied, because it depends on the expert qualifications, the experience, methodologies they have used. So even the all expert testimonies does not hold the same weight, because arbitrators will be able to evaluate the credibility of each expert based on their backgrounds and also the soundness of the methodological approach they have used and how they also presented their case during the cross-examination, which is one important factor as well, the cross-examination. One also misconception could be that the parties or in arbitration, sometimes they think that the expert evidence is always necessary. Parties sometimes assume that the expert evidence is required to prove their case, regardless of the issue involved. Sometimes in reality, the expert evidence should only be introduced when it's necessary to resolve the issues that are actually beyond the common knowledge, as we say, of the tribunal. So sometimes introducing the unnecessarily expert evidences could lead to an increase of the cost and time delays without adding any value to the case. The last one, which is I could say about that expert, and this is very common, can address legal issues. It's often mistakenly believed that expert can opine on legal matters or legal interpretation, or even giving sometimes conclusions. The role of expert is limited to the matters within their technical or specialization field. Okay, so the legal issues are not actually, or I would say, strictly within the purview of the tribunal, and the parties' legal counsel and experts should not overstep into the areas involving the legal judgments. So I think these are very important misconceptions in the preparation and the presentation as well of the expert evidences. This could help, I think, enhancing the effectiveness, the efficiency of how we can of the whole arbitration process, and also it's important to ensure that the expert maintain the rules, as we say, and the people or the parties involved in this arbitration understand the role of the expert and what is the expert evidences and how it will help them to reach or actually clarify the complex case of the report. You're muted, Antonio.
Thank you very much, Sadan. Yeah, I absolutely agreed. There are a lot of misconceptions regarding expert evidence in particular, possibly because expert evidence in arbitration is a different animal to expert evidence in local litigation. Before, for example, courts and the GCC, expert evidence has a different procedure and very different process in place. So for those that are newer to arbitration, absolutely important to get the right advice regarding expert evidence. And exactly as Saad says, experts are supposed to provide their independent opinion rather than represent a particular party. That is obviously absolutely key. We will unpack these issues in a bit more detail, but Dr. Ismail already said at the very beginning, the primary duty of the tribunal is to render the enforceable award. So just drilling into a little bit into what that means for the arbitrator. What is the arbitrator thinking when the arbitrator commences their duty as part of the tribunal? So, necessarily some of the values that arbitrators favor are, for example, transparency. For example, it is natural for an arbitrator to request the parties to provide information about their proposed procedural next steps, any delays, any changes, for example, to the counsel teams that may impact the independence, etc. Transparency is absolutely important. There is, of course, a potential misalignment here, because it may well be that transparency is not in the interest of one of the parties. And maybe that transparency, therefore, becomes a thorny point where there's a misalignment between the tribunal and the party. Similarly, another important aspect is promptness. Again, arbitrators, and this will typically be in your procedural order number 1, expect prompt, swift communication regarding any changes, any delays, any requests, applications. Again, strategically, that may contradict what a party wants to do. A party may wish to wait until it raises a particular problem to the tribunal's attention. So you can see again, there are some other potential misalignment. And both transparency, promptness, they go to one of the sort of key aims, which is respect for the procedural rules, for the rules of the institution, but of course also the rules of the particular arbitration, procedural order 1, or wherever those rules are contained in that particular case. So there are these potential misalignments between what arbitrators may want and what counsel may be advancing. Counsel, of course, are acting for parties. As engineers had already said, they are not independent as such, and they often have drank their Kool-Aid, so to speak. Apologies. So counsel often will be representing particular client strategies or instructions. Dr. Ismail, my question to you was, how do these misaligned strategies between what counsel may want and what arbitrators, tribunals want, how do they impact arbitration outcomes?
Well, the tribunal has an obligation to render an enforceable award, as you have mentioned several times, and I would like to highlight from where it comes. So it's mentioned in the ICC rules. For the audience, from where does it come? It's mentioned in Article 42 of the ICC rules, and it's also mentioned in Article 32, Paragraph 2 of the LCIA rules. So it's important to know from where it comes from. What is this obligation? I am of the view, and a lot of scholars are of this view, that it is an obligation de moyens. So it's an obligation to exercise care. It's not an obligation to achieve a certain result. And even you can see it in the language provided in the rules. So the arbitrator shall make every effort to make sure that the award is enforceable in law. And you see in the LCIA rules, it's mentioned that the arbitrator shall make every reasonable effort to ensure that the award is legally recognized and enforceable at the arbitral seat. So it is. So the arbitrator has a duty to ensure the enforceability of the award at the place of arbitration, and also we can add to it the possible places of enforcement, but not in every place around the world. Also, the arbitral tribunal can take into consideration also the requirements of the New York Convention. It's reasonable to say so. Then how to fulfill this duty? So the arbitrator has to ensure that the award is drafted in a proper form, so to ensure that there are all the formal requirements of the seat and the possible places of enforcement are complied with. The arbitrator has to respect due process, so he or she will need to, at the same time, respect due process, respect efficiency, make sure that the celerity of the arbitration is not compromised while respecting due process at the same time. Also, the arbitrator the parameters of has to be bound by the case pleaded before him or her. He cannot decide a case that was not pleaded by the parties, because this would lead to compromise the enforceability of the award. I think this would cover this obligation to ensure that the arbitral award is enforced.
Yes, thank you. Yeah, absolutely. I mean, those are all the issues that are on our mind of the arbitrator, of the tribunal. And of course, necessarily, there may well be conflict with the priorities, often short-term priorities of counsel that making submissions to arbitrators. Engineer said, moving to sort of the misalignments on the expert front. Can you offer any examples of how to align strategies relating to expert evidence with more effectively with what arbitrators are looking for, all the things that Dr. Ismail has just talked about in terms of enforceability? How do we help aligning the priorities regarding expert evidence in particular?
Thanks so much, Antonia. I think from like practical approach, we can provide some examples. First of all, the early expert engagement is important because involving the experts in the arbitration process, due to their specialized knowledge in the case, it could actually help the strategy from the beginning. This will allow, I think, deeper understanding and help how to shape the case narrative according to what could be most relevant to the dispute. One more thing is there could be also how to define the expert scope clearly. So clearly, the outline of the scope and the role of the expert to focus their efforts on relevant issues. This prevents actually the unnecessarily divergence, and it ensures that the experts themselves and the expert reports directly addressing the arbitration's key concerns. The more things also, or another thing or another approach could be that the strategic expert collaboration. So this is actually when you include the expert in the strategic discussions about how their findings will be presented. This will ensure that their evidences will be aligned with the overall case strategy and is presented coherently during this arbitration. One more thing also that could be the mock-up cross-examinations, if it's allowed. In some jurisdictions is allowed. To prepare your expert for the real arbitration sitting by conducting this mock-up cross-examination, or not mock-up, it's mock cross-examination. This practice actually could help the experts to anticipate what is the potential questions and defend their own findings effectively under the pressure. You need also to prepare an executive summary. You need to encourage the experts to produce these concise summary of their reports, because it's very important. Sometimes the experts only understand, why experts exist, why this profession exists, because basically it's a very complicated thing and we need somebody to explain it in a way where somebody doesn't know anything about this role can understand it. So having an executive summary, encouraging this expert to produce it, it could highlight the key point. This will be useful to make a quick references during the deliberations, and helping also arbitrators to grasp a very technical and complex matter. And again, at the last, if you have a good presentation of your thoughts, making transparent presentations, so we need to advocate and help the experts to make a transparency in their presentations and how they can present their expert evidences. This is, of course, they need to be disclosing all the relevant data and assumptions, make this also upheld up to the ethical standards. I think these strategies could help the legal team sometimes to present the expert evidence more effectively. And they can also ensure that it may be aligned, it could be aligned with whatever the arbitrators are looking for, which may be at the end help enhancing the perspective of a favorable decisions in their favor.
Absolutely. These are comparatively straightforward tips that yet so often ignored, and so important, because they do go exactly to what the arbitrator has to take into account, what the tribunal needs to think about. And if you create, as you say, a list of the issues, if you help with the transparency of the report, those are all very important considerations from the arbitrator's perspective, who is reviewing the evidence of the expert. So absolutely key. But before we move to the next line of questioning, I see there is one question that I think we can respond to from the audience suitably now. There's a question, what the role of the arbitrator is when there is a issue, when there's a claim of a criminal aspect. So for example, if one party says the other party has committed a crime against it, and this issue arises in an arbitration. Dr. Ismail or Engineer Saad, would either of you would like to comment on this question?
I'll leave it to Dr. Ismail, of course.
Okay, in this case, if the arbitrator is sitting in a jurisdiction, because the problem is, or the tension is between, the arbitrator has an obligation of confidentiality. But at the same time, if he can see that a crime has been committed and he is sitting in a jurisdiction where he has an obligation to inform about any crime that he or she could observe and see, here I think the criminal law would prevail and the arbitrator would have to inform the authorities about this crime in case he would find himself liable under criminal law. So the arbitrator will be forced to do so. So there is a tension here between the obligations vis-a-vis the criminal laws of the seat against his or her obligation of confidentiality vis-a-vis the parties and the parties and the case in itself.
Yes, yes, and of course, thank you very much, Dr. Ismail. There's also the potential in those kind of situations that a party may commence criminal proceedings in the criminal courts and before the prosecutor. And then what we often see in arbitration is that the other party then requests for the arbitration to be stayed. And that's another aspect, I think, that also comes into play in this kind of situation. And again, I mean, it depends very much on the applicable law, whether the arbitration needs to be stayed, whether the tribunal has discretion. But yes, I think there are a few issues the tribunal will be thinking about if there's an issue of criminality. And of course, it's quite common to see, for example, forgery allegations in arbitration. You will often see arbitrators considering forgery, civil forgery matters within the arbitration. Of course, criminal forgery or any other criminal decisions are outside of the jurisdiction of the tribunal. But it's certainly a very interesting question. So thank you for that, because there are various things at play here that will need to be considered. Just one more question, I think that also fits nicely here from Ms. Claudia El-Haq. Thank you very much for submitting it. This question relates to pleading points. It's something that English lawyers discuss a lot, but I'm be very keen to hear Dr. Ismail and Engineer Saad think. The question is, would a case that was not pleaded by the parties prevent the arbitrator from implementing adequate legal provisions to the situation at hand, in case the parties relied on incorrect provisions? So again, this is a very common situation that I see as arbitrator, where basically a party has not relied on the right provisions. It has relied on the wrong provisions. So what does the arbitrator do? What is the sort of the misalignment here? Dr. Ismail, maybe this one was also for you.
Thank you very much. So this raises the principle of nubit curia arbiter, if we use it in arbitration. So this means that the arbitrators, they know the law, or the judge knows the law. So in this case, what the arbitrator should do is that during the hearing, he would ask a legal question to both parties and ask submissions from them, so that with the post-hearing submission, the arbitrator would get an answer to this legal question. So if the arbitrator decides based on these legal provisions that were not invoked during the first 2 rounds of submission before the hearing, the principe de la contradiction would not be violated, and the parties would have a reasonable opportunity to comment on these and to provide an answer to these legal questions. So the tribunal can rule without being in an ultra petita or a violation of due process when rendering the award. And this is part of the arbitrator's obligation to render an enforceable award.
Yes, very eloquently answered, and exactly what I see typically as well. Indeed, I think one of the important points for counsel is to watch out for questions of arbitrators and very carefully respond to questions, because often the question may well be directed, as Dr. Ismail has put, at an issue that may currently be unclear in the submissions, but the tribunal, the arbitrator may know that there are additional submissions that could be made on related points. So this is one way to deal with this, because of course we don't want to have an award that is ultra petita. So moving back to the topics of our webinar, and we'll come back to further questions. Please do keep posting. The next sort of topic we wanted to drill into is dilatory tactics and procedural correspondence. So just a sort of general question, Dr. Ismail, you sit, of course, not just as arbitrator, but you see hundreds of arbitrations in your capacity as part of Corsica and the Corsica Institute. Do you often see this kind of dilatory tactics? How obvious are those kind of tactics to arbitrators, and what's sort of the impact of those kind of delay tactics in procedural correspondence?
No, they are very common, I have to say, and more, and the council become more and more creative in doing them. So as an institution, your response can be through amending the rules or issuing practice notes. And an example of the amendment of the rules, our rules of, if you compare our rules of 2011 and 2024 regarding the allocation of costs. So under our 2011 rules, the allocation of costs was especially based on the principle of costs follow the event. So the losing party would bear the arbitration costs. But under the new rules, we have introduced also the concept of procedural good faith. So the tribunal will take into account the party's contribution to the efficient conduct of the proceedings and the avoidance of unnecessary delay and expenses. And certainly dilatory tactics would cause further expenses and would cause delay. So if a tribunal even would also take into account that as well, and not only the principle of costs follow the event.
Yes, absolutely. And I think it's very important as arbitration as an industry matures. You know, I've mentioned earlier how much more prevalent arbitration is becoming, especially in the Middle East. It is important that arbitrators do use their discretion and the rights that they often have under the applicable rules to penalize on costs for this kind of behavior. Because exactly, Dr. Ismail, as you say, where it is obvious to the tribunal that tactics are being employed for no apparent reason besides delay, then necessarily, of course, that is something that the tribunal should be taken into account, and that in itself may prove an impetus to the parties to discuss. Because, of course, what can parties do? There are effective ways of managing procedural correspondence. Tribunals, again, thinking about what tribunals want, tribunals would like parties to discuss any kind of procedural arrangements and to come to the tribunal with one joint position. Even if the position cannot always be agreed, what the tribunal would like to see is that the parties have attempted to, that they have done those so within the appropriate deadlines, they have done it cordially, politely, and that they come with one joint letter or email, which may set out two sides to be part of the position, but it attempts to reach as much agreement as possible. To my view, this is one of the beauties of arbitration, because it allows parties and their counsel to really craft the type of procedure that works for both parties. And it's also very much appreciated by tribunals to have this kind of dialogue between parties that then avoids potential lack of transparency, dilatory tactics that we've discussed. So those are the kind of ways to avoid these issues that we were talking about in terms of delay procedural correspondence. But Sad, just turning to you, looking at how arbitrators can ensure that procedural fairness is maintained. We've heard, of course, about cost consequences at a later stage, but do you have any other thoughts on what do arbitrators do, what do tribunals do as the procedure is ongoing? What should they be doing? What are they thinking about when they experience these kind of delay tactics?
Thank you.
Well, I have. Okay, it's the question is for Saad, not for me. Or
please
for me.
Go ahead, Doctor.
No.
For me, but
if the question was addressed to you, please answer.
But لا يفتى ملك المدينة يعني زي ما بيقولوا. I think to ensure procedural fairness among these dilatory tactics and extensive procedural correspondence, arbitration can take some strategic steps to focus. I think they can focus like in regular procedural conferences. Some of these conferences may be curricular, like play a curricular role to the procedural. Maybe they can have like regular procedural conferences. This is like a formal meeting. They held it like intervals during the arbitration process, where both parties with the tribunal decide on the procedural issues. And they can also, during these conferences, the arbitrators themselves can address anything or any potential procedural disputes and provide like immediate guidance on how these matters or how these issues need to be resolved. One more thing is also they can enforce procedural timetable. So they can have, they can enforce strict adherence to whatever procedural timetable agreed on or they produced at the beginning. And they can closely monitoring this procedural timetable and like address the parties if there is any deviation from this one. One more thing, it could be like they can even streamline the procedural correspondence. So they can even try to cut down on the unnecessary procedural correspondence. They can direct the parties to limit their communication to the essential matters and also to consolidate the procedural requests. They can also have a proactive role in the management of the proceduring. By taking proactive roles in managing these procedural, they can anticipate and mitigate these tactics. They can set down agendas for hearing. Sorry, they can set agendas for hearing. They can decide on the admissibilities of evidences, for example, on early stages of the procedures. They can schedule sessions to address specific issues. So this is all a proactive role. They can also have consistent applications of rules, like transparent and consistent application of these rules. So when you have or maintain a transparent approach in applying these procedural rules and ensuring that these rules actually are applied consistently to all parties, this will help also preserve, I think, the integrity of the process, and it kept its fairness, and the fairness is actually encouraged within among the parties. These measures, I think, it could help, to minimize this kind of delays in the procedure by the arbitrators.
Absolutely, thank you. Strong procedural management by the tribunal, and that of course goes back to who is the tribunal, who is sitting on the panel, who was appointed, which is why again it's very important to know who it is that you're acting before. And yes, strong procedural tactics.
Yes. Can I add something to this note, because I was hoping to comment on Dr. Ismail's answer to Claudia, because he answered something very important, but it's only required an experienced arbitrator. this tactics or these answers required only a very experienced arbitrator. And this is maybe we can have another section on how to select the arbitrator, because I think this is very important also. It's the key point or the keystone in the whole arbitration process.
I absolutely agree. Yes, how selecting an arbitrator, that we can have several sessions on that point. That's very true. The last two topics for our discussion today. One is on. Sorry, yes.
Sorry, can I add something? Because I wanted to give some example about a real case on which I served as president, and I have never experienced in all my career the number of dilatory tactics of the respondent's counsel in that case. The respondent had a strategy to delay the case. I will not disclose why, but it was clear, and the tribunal understood that the respondent wanted to delay the proceedings. It has a vested interest to do so. For a reason, we could not set the date of the hearing during the first CMC, but once we finished the production of documents phase, the tribunal communicated with the parties to try to set a date for the hearing. The respondent made all attempts in order to delay the hearing. So the tribunal responded by providing the respondent with several alternative dates for the hearing, and the respondent was still objecting. So the tribunal noticed that the respondent did not object to the dates of Ramadan, Ramadan was in April. So perhaps the respondent thought that the tribunal was not going to hold the hearing in Ramadan. So we proposed to hold the hearing in Ramadan. So the respondent found that the date of the hearing was going to become earlier. So he finally accepted not to hold the hearing in April and to hold it in May. Another attempt, after the end of the second round of submissions, the respondent alleged that the claimant has provided some technical expert opinion within the quantum expert opinion. So instead of responding in the second, the rejoinder submission, the respondent wanted to have the opportunity to submit a technical responsive expert report. So what the tribunal did, in order not to delay the hearing, is to permit the respondent to submit this technical responsive expert report together with the agreed joint expert report that was supposed to be submitted with the quantum experts of both parties. Then, one day before the hearing, the respondent wrote to the tribunal that one of its factual witnesses is ill of cancer, so is suffering from cancer, and then it wanted to delay the hearing. So we did not delay the hearing, and we proposed that after the hearing, after a month, during or before the closing submissions, the post-hearing briefs, we can convene remotely for 2 hours and cross-examine this factual witness. So this is to show that the tribunal must stick to its procedural calendar and try to accommodate as much as possible these types of dilatory tactics, because we never know what the judge of annulment of setting aside proceedings would think. And I have heard that this award has been enforced, and the tribunal was able to timely render the award before the occurrence of the event that was awaited by the respondent. Sorry for this, but I think these were practical examples that I wanted to give to the audience on how to deal with dilatory tactics. Thank you.
It's extremely, extremely interesting, and actually answers one of the questions. Dr. Thiel-Zimmer, thank you for the question, which asked exactly that. What is your most challenging experience? So thank you very much for sharing, and the tips obviously are absolutely vital, and very good to hear that it was not set aside, because that is, as we talked about earlier, the primary obligation or duty of the tribunal to think about or to try, as you said, to have an enforceable award. So that's really good to hear. There's a question also as to whether the rules of an institution help arbitrators guiding the parties to avoid, the tribunal being too forceful. And just very briefly, of course, the rules are very important, and for that that reason, you need to choose the rules of the arbitral institution very wisely. Very important to look at exactly what the rules provide and how helpful are they. But the rules of institutions are not going to be the full answer, because of course parties are crafty. They will try and come up with ways of achieving whatever objective they may have, and therefore, it is the tactics that the engineer Thad was describing. What tribunals can do are very important to keep in mind, and it is important to have a tribunal that is not just going to sort of sit and watch, but in fact will be active and actively overseeing the procedure. I think, Sad, you mentioned sort of potential meetings as well. I mean, I think it's a great way for the tribunal to have good oversight. For example, have a CMC, have a procedural hearing halfway through the arbitration, get in front of the parties for complicated matters, and consider what issues are ongoing at that time and whether any need resolving. It's not going to be necessary every time, but for the important big matters, it may well be useful to have that kind of oversight as well. There was just one other question, I think, which also fits to exactly what we're discussing. Thank you for Dr. Ahmed Darvish, regarding this misalignment between council, parties, and tribunals, because as Ahmed puts it, council are often under pressure from their clients to submit various positions that the clients are convinced about, the clients feel very, very strongly about. The clients have necessarily been then harmed. They have been living this often nightmare for a very long time. And we as counsel then are put in a position where we may disagree with the client, but we have this balancing exercise to take into account, knowing, on the other hand, that the tribunal will look at the position very differently. I think it's an excellent question. It's something that I see, very regularly in my practice, where it's obvious when I sit as arbitrator that a party is advancing a position of their client, which may not necessarily be a winning position. So I think you have to be very careful. I mean, that's my personal view on these kind of issues. You have to advise your client with respect to what is the most persuasive case you can put forward to the tribunal. And if the particular position the client feels strongly about is not that, then you need to have a strong conversation with the client that it's not in their... So with that, I think that ties us very nicely to the next topic we were going to discuss, and that's submissions, effective submissions before the tribunal. So Dr. Ismail, if I could start with you, what elements make for a compelling case presentation in the eyes of the arbitrator?
I think the counsel must try as much as possible to make its case, his or her case, simple. Even if the case is complex, the more we make it simple without compromising, of course, the requirement of providing all the evidence, but the more we make it simple, I think the more it will be easier for the tribunal to digest it. That is very important, and try to know, of course, your tribunal. I have seen a case where know the nature of the tribunal and the background of your tribunal. I have worked long time ago as counsel in a case, and the presiding arbitrator was an eminent professor of international law who has sat in many international arbitrations, but he had a civil law background, and both parties provided experts, but for him, the experts were the counsel of the parties. So this, of course, is not in line with international arbitration. Personally, I do not like at all to resort to tribunal-appointed experts. I think it wastes a lot of time. I prefer very much when counsels, they bring their own experts, and the tribunal will decide and will take from both expert reports and will decide accordingly without resorting to appoint a tribunal expert, because it really wastes a lot of time. But that tribunal was not fit for that. And after that, we have pleaded our cases with our respective experts. And after the cross-examinations, the tribunal ended up appointing a tribunal expert. So it was really a waste of time. So we need to make sure what type of arbitrators we have appointed and what fits them better. The submissions, they must be properly written with footnotes that are very clear. Sometimes there are information that should not just be referenced in a footnote. Sometimes I see counsel within the submission, they provide photos, they provide some drawings that explain better to the arbitrators what do they mean to do. If they want to go into the details, they can use witnesses, factual witnesses, and the factual witness will say a lot of what they cannot pack their submissions with it. But be careful when bringing a factual witness, because if you bring the wrong factual witness, he is able to, demolish all the effort that are made by the counsel, because some people, when they don't know how to be cross-examined, they do not know how to bear the pressure of cross-examination. So when you bring an expert who is not credible when cross-examined, I think this can do a lot of harm to your case. So in this case, it's better to rely on written evidence rather than relying on a witness that would not be credible.
Some more fantastic points, and there's so much to unpack there. We could spend a few more hours discussing it. But absolutely, I mean, rather than submitting a unhelpful witness evidence, having a more helpful, persuasive submission can be the answer. So that's absolutely right. Just before moving to Saad, Dr. Ismail, there was one question that also relates to what you were just saying now, relating to expert witnesses appointed by the tribunal. So Munar Alamar asked, to what extent can one of the parties refuse to appoint an expert that was chosen by the tribunal, by the arbitration committee? Would you be able to respond to this one, please?
Well, usually when a tribunal appoints an expert, there must be a consultation with the parties. But if we grant a party a full veto right to oppose to an expert appointed by the tribunal, this can be counterproductive if the tribunal really intends to appoint an expert. So it's not a veto to object. There must be compelling reasons and objective reasons to object. So whether the party doesn't want to waste time or there is an issue of conflict of interest that should be raised before the tribunal. So, but it is also dangerous to object. So this is if the claimant is objecting. We need to differentiate. If the claimant is objecting, I think it is dangerous, because if a tribunal is resorting to appoint an expert, this means that the claimant has not evidenced its case in the eyes of the tribunal. So it would be risky for a claimant to object. But if a respondent is objecting and is not a counterclaimant, it could be viewed by the tribunal that the respondent is trying to, it's a dilatory tactic. So there must be compelling reasons to this objection. One thing that I want to mention about expert appointed by the tribunal, I think, the only advantage, and this is something I have seen, when an expert is appointed by the tribunal, the expert is capable of bringing evidence from governmental authorities. And this is something that a party-appointed expert cannot do. Because in our jurisdictions, if you need a piece of evidence or a certificate or whatever, or an information that is only within the custody of a governmental authority, the only way to bring it is an authorization from the tribunal. And a tribunal-appointed expert would act like a court-appointed expert, and these governmental authorities in our jurisdictions are used to comply with orders of judges, and I have seen orders of arbitral tribunals to get this evidence. So I think this is the only exception where I would accept the concept of tribunal-appointed experts, absence of an agreement of the parties. If the parties agree to this mechanism, and if we are going to have a tribunal-appointed expert in our jurisdictions, it is common in domestic cases to require it. They should require this from the very beginning of the case. So before even rendering submissions, we will start with the tribunal appointing an expert. The expert would submit a report, and then we will have a submission on that report. But this is a domestic way of dealing with cases, but it is the only efficient way of doing it. And then we will have submissions and then a hearing on that. But I have seen it, and it was sometimes efficient. For example, in a capital market case, one of the parties needed access to bank accounts and to assess the bank accounts of the other parties. So there was a need of a tribunal-appointed expert to do this job and to assess bank accounts and documents relating to bank accounts. So it was useful to have it. But really, this is very, very exceptional, and I do not encourage it usually. Thank you.
Yeah, another fascinating perspective. And again, it goes to who is your tribunal and how carefully have you chosen? Because when you choose a tribunal as distinguished and experienced, as Dr. Ismail describing, then of course watch out what the tribunal suggests, because if the tribunal in a rare situation may wish to appoint a party-appointed expert, there may well be good reason for that, and then it may well be not advisable to reject this, especially as we heard for claimant. So very, very interesting strategic points there. Asad, for the tribunal-appointed experts, what about expert reports, and how are they most effective, most useful for a tribunal?
Thank you, Antonio. Just a quick comment on the tribunal-appointed experts. I agree, of course, with what Dr. Ismail said, but I just need to add something that in some cases, you will find the two experts appointed by the parties are very far from each other. So, for example, you see someone saying 0 and someone saying 100, and the tribunal actually does not have the required experience to make a judgment. And I've seen it in some cases where they had to appoint a tribunal expert just to make sense of these submissions, because they cannot actually understand who's right and who's wrong, specifically in very complicated engineering matters, oil and gas, or something, sometimes rare specialities where there is no much knowledge in the market, where by common sense, even if the arbitrators are very experienced, are willing it. So, but of course, I do agree with Dr. Ismail. It's a good practice to have the party appointed expert, much more better than having the tribunal appointed experts. And I would agree also with Dr. Ismail.
Yeah.
Please, Doctor. Okay, so and I also agree with Dr. Ismail on how he mentioned how to present the case. I think it's also common on how to present the expert evidence or an expert report, because the arbitrators actually prefer expert reports that exhibit many characteristics. The most important of it, I would say, to be direct. Like to be direct, you have to be able to address the core of the issue, because they won't actually a report go straight to the point without unnecessary elaborations. The second thing, which is also I agree with Dr. Ismail, that it's a graph. They need a visual aid. They need to see something, because the effectiveness of using charts or graphs or table to illustrate the key points can actually make a very complex information more accessible and easier to understand. We need to have the basis of the calculations. So you need to use evidence-based calculations. So the report actually should be clearly demonstrate how these calculations are drawn from the data, or how you based this or provided this analysis. And you need to show the logical progression from the evidence to this conclusion, just not to make it 1 then 10. You need to write about it. you need also to have a well-documented methodologies, and you need to include a clear explanation of these methodologies used to enhance the credibility of this report. I think by using these elements, it will help to ensure that this expert report actually are having the proper impact and assisting the tribunal to make an informed decision effectively.
Yes, thank you so much. Again, very clear points, but often, unfortunately, ignored. So it is very important to think about exactly what Engineer Saad is saying when making submissions. What we often see, far too often see, is that submissions include various issues that are not, in fact, issues in dispute. Sometimes we see submissions that are largely irrelevant. So one of the tactics that has been used over the last few years is to create the issues list to identify what it is that it is in dispute, which issues do the parties need to present to the tribunal, and where does each party need to succeed. And that helps keep the parties within the remit of the arbitration. I would say without an issues list, most, if not all, arbitrations see at least some issues that are not relevant. And that is, of course, from the tribunal's perspective, not just wasted time and money, but also often detracts from what needs to be determined, takes away space and energy from the issues that are, in fact, important and in dispute. So that's, from my personal perspective, a really important consideration when in making submissions. Always start looking at what is it that you need to prove to the tribunal. So our final issue in for discussion, and I've incorporated quite a few questions, but we'll keep going with the questions as well afterwards. So, the final issue for discussion is hearings and post-hearing. Last but definitely not least, because it's a very important issue when considering how to present to the tribunal. So Dr. Ismail, if I could start with you again, what should legal teams, what should counsel be thinking about, be aware of when they're navigating the dynamics of an arbitration hearing, when they're thinking about what is it that the arbitrator wants from the hearing?
So in a hearing, so the question is on the hearing or the post-hearing? The hearing, yes?
Yes, so hearing, first the hearing, and then we'll move to the post-hearing in a minute.
Very good. So the hearing is a fantastic opportunity to reveal the truth. So a lot of truth is revealed during the hearing. It's a very important milestone, especially for complex cases. So the parties are not allowed to plead a new case during the hearing because it's against due process. So able counsel in their opening statement would use PowerPoint in a very visual way to represent their case, to present their case again, but in a different manner. They would use columns, tables with a visual effect, and their ability to really do very good PowerPoint presentation. In addition to the oral capabilities of pleading, this can help the tribunal a lot in understanding their case in a different manner. And a successful opening statement, if used by the arbitrator during the deliberation, this means that it's not only for the arbitrators during the hearing, but the arbitrators, they get a copy of the opening statement, which would reference to the most decisive evidence and the most important evidence, and it can help the arbitrators during their deliberation. So that would be a successful opening statement. But if in your PowerPoint we just see paragraphs and reference to exhibits, I think this would be a repetitive PowerPoint that would repeat the submissions, and that would not be fit for the purpose. The second, I think, the second benefit of the hearing is the cross-examination and examination. So as I have mentioned, you must choose the proper witnesses and the proper experts who would withstand the pressure of cross-examination. You must also, as a lawyer, be very well trained to cross-examine. Some lawyers they have the talent of writing, but they don't have the talent of cross-examining. So you must select from among your team who is very good in cross-examination to do it. A problem that a tribunal would face, and I think the council and the parties should consider it, in international arbitration, factual witnesses are sometimes used to testify on technical issues. This is acceptable in international arbitration, but to a certain extent. If really the matter is very, very technical, I think the tribunal has the right to have a technical expert appointed by the parties to help the tribunal, and not to solely rely on factual witnesses who are the employees of a party. Even if they are engineers, they are still not independent. So I think this is also very important. And some lawyers, I have seen some lawyers, they are very good in writing, but they don't know how to cross-examine. And I'm talking about lawyers from our region. So they start pleading. They are unable to cross-examine the witness. So they start pleading in front of the tribunal while they are expected to cross-examine a witness. And that is really counterproductive. I have also even seen a counsel objecting to a question from the tribunal to his witness. And for me, that was very amusing. I have seen it for the first time. So this is just to show you sometimes how some counsel are really not well versed in cross-examination at all. So I think these are very good or very useful from my point of view advices to be given to counsel, not the very experienced counsel, but some counsel in our region. Thank you.
Absolutely, and we could spend for a lot more time on this, because of course, you know, the other issue with fact witness evidence, as well as preparation of fact witnesses. There are a lot of misalignments here between what the tribunal wants, i.e., you know, attempting to deliver a enforceable award, and on the other hand, counsel wanting to potentially give too much training to their witnesses, or on the other hand, not enough training. Again, it may be that the counsel comes from different backgrounds and has different expectations as to what's right regarding witnesses. But it's very important to think about these kind of issues and think about them from the perspective of international arbitration, not the perspective of a particular court in which, you know, the council is generally active. So these are all vital points. Very briefly on experts and expert evidence in the hearing, before the tribunal, oral expert evidence. Sad, do you have some brief comments as to how is expert evidence effective in the hearing?
Thank you, Antonia. I think quickly we can say that to present the expert evidence in the most persuasive manners during the hearing, particularly in direct and the cross-examination scenarios, I have few tips I think would also interact with what Dr. Ismail said. You need first of all to have a preparation for your direct examination. So the expert should actually thoughtfully prepare to explain their findings in straight forward way and confident matter. This is very important for experts and presenting their evidences, because this preparation should include a rehearsal of direct examination to refine how actually the expert themselves communicating the key points and ensuring that there is a clarity of the issues they are presenting and persuasive. The second element could be that they need to highlight the key findings. So during the direct examinations, they need to focus and they put focus on the expert main findings and how these implications of these findings related to this case. One more issue also that they have to effectively respond to the cross-examination, because they need to be prepared to defend their methodologies and findings under this cross-examination, because as you understand, the counsel is always going after the experts for whatever methodology. So because they are trained hopefully they are trained to defend their methodologies. They also another matter, so they need to have a consistency in their testimony. So they have to ensure that the expert testimony is consistent with their written reports and the other cases documents. This will enforce the reliability of the experts and their findings. They have to have a clear communication. Basically, experts, despite how important or how fantastic your expert's report is, sometimes we have seen experts' reports with exhibits of 10,000 of pages, but I'm sure that nobody will read these ones. So you need to have, you should use a clear, understandable languages and avoiding the overlying technical terms. You need to also understand, as Dr. Ismail was always saying, who's your panel, who's your audience. So you need to give them the explanations in a proper way. They allow them to help them to maintain the engagement and the understanding of these arbitrators. So these tactics or practical approaches, it could enhance the effectiveness of this expert testimony and help actually it make it more likely to be, I would say, influentially, positively taken into the taken by the tribunal, and also could help the tribunal to make a faster decision-making process.
100%, 100%. My very final question before we move to some of the audience questions to Dr. Ismail. Now looking at the post-hearing brief, and sort of what are parties supposed to think about after the hearing? What are tribunal's expectations at that stage?
Thank you very much. So there are two ways. Either we have closing oral pleadings or closing submissions in the hearing, but that's quite rare in international arbitration. Usually you have the post-hearing written submission. That is the most common. There is something I want to say, since we are also, before dealing with that, and I have done it once based on a proposal of one of the co-arbitrators. Co-arbitrators proposed to me, I was presiding a tribunal, to require from the two party appointed experts to meet. They were both quantum experts, to meet right after the hearing for a few hours and to narrow down their figures. So that, and the parties agreed. So the two of them, they met. It took them only one day for a few hours. They narrowed down their differences, because after they were cross-examined, their positions changed a little bit, and they provided us with, a sheet with their figures and the justification of their figures. So this was very helpful for the tribunal to decide on quantum issues. That was a post-hearing requirement that the tribunal asked for, and the parties complied. It was very helpful. Few days after the hearing, we had this joint sheet that has complemented the expert reports, rather than for the tribunal to appoint tribunal experts. Regarding the post-hearing written submission, if we have able counsels, and during the 2 rounds of submissions, we had good submissions, so the post-hearing brief would be not very long. The tribunal can set a maximum number of pages. It could be for 15 to 20 pages post-hearing submission. That would suffice. And this submission, we should not repeat everything that was in the previous statement of claim and rejoinder and reply, etc. So the written submissions before the hearing, it's a post-hearing submission that would rather focus on what has happened during the hearing, would refer the tribunal to the transcript of the hearing, to focus on some strong statements that were made during the hearing when their respective witnesses were examined, or when they were able to trap the opposing party's witness or expert during the cross-examination. But the post-hearing brief should not re-argue all the case. The tribunal are in a mindset of drafting the award. Usually the presiding arbitrator would come to the hearing with already the positions of the parties already written within the award, and the post-hearing brief would supplement these positions, not through new pleadings, but because the post-hearing submission should not contain a new pleaded case, but to exploit what has been said during the hearing. The tribunal will not read hundreds of pages of transcript. Usually this does not happen. So the post-hearing would guide the tribunal on the most useful parts of the transcript to use them while the tribunal is in the award writing mode and deliberating. I think that's the best way of using a post-hearing submission. And then this is when you have able international lawyers. Sometimes the lawyers did not do a good job before the hearing in terms of submissions for various reasons. So in this case, the tribunal may exploit the fact that we have a post-hearing submission and would ask for a more lengthy post-hearing submission, properly referring to the exhibits, and would use this entire submission, long submission, to draft its award. So that is, these are two types of post-hearing that the tribunal may require. Thank you.
Absolutely. And another very important stage, of course, that is often ignored. It's towards the end of the proceeding, but yes, it's the last opportunity to answer questions that the tribunal may have.
Of course, answering a legal question, yes, of course, or asking a factual question. So the post-hearing is, of course, an opportunity to do so. I agree with you.
Yeah, thank you. Thank you. So really fantastic topics for discussion. There's so much more we can discuss. The questions, some of the additional questions in the chat relate to some of the issues we were discussing. So, for example, there's a question from Muna Alama. Thank you for that. If the arbitration period is prolonged and it becomes apparent to one of the arbitrating parties that the arbitration committee or that the tribunal is unable to deal with the existing case, what is the procedure and what actions are available to the arbitrating parties? So I think this is a question which has a very significant time. In my circumstances, this happened when a case continued for 10, 15 years, and one of the arbitrators passed away in the meantime. And then you have a procedure in place to replace the arbitrator. But maybe Dr. Ismail, do you have any other experiences from the institutional perspective when you have this arbitration period and the tribunal is unable to deal with the case?
Well, so if you have a tribunal that is not delivering, there are many reasons for a tribunal not to be delivering. So the tribunal might know, but might be well versed in terms of merits, but is not dedicating sufficient time to issue its award. So here the role of the institution to follow up with the tribunals and to make sure that the tribunal delivers. Or the parties would have the right to remove the arbitrator, not to challenge, but to remove the arbitrator because the tribunal is not delivering. But what if a tribunal is unable to deal with the matter in dispute? How would the party know? That is the question, because this is the secret. These are secret deliberations. How would the parties know that the tribunal is unable to deal with the legal issues? I think it would be the mistake of the parties. They have appointed a tribunal that is not legally able or not fitting or not suitable for the case. I think that's the fault of the parties. But it's also the fault of the arbitrators having accepted the case and they don't have the legal expertise to decide upon it. That's also, but it would be really a very big problem for the parties.
Yes, quite. Quickly, there's one question regarding the issue of delay tactics that we talked about earlier. Thank you, Ali Ayad, for the question. In order to avoid delay tactics by disputed parties, the tribunal proceeding timetable should be agreed and inserted in the arbitration agreement. In case of party breach, it will be liable if there's a stipulation in the agreement So generally speaking, the tribunal inserts the timetable into procedural order 1, which often the parties confirm and in review before it is issued. I have not seen a timetable inserted into the arbitration agreement as such. And the query, you know, the issue, I think, from my perspective, is in any case, in procedural order 1, as you typically do, parties may nonetheless be asking for extensions. They may be coming up with reasons why they need extensions if they're trying to delay, like Dr. Ismail was discussing. So I don't know, Doctor, if you have any additional views on this kind of issue in terms of, you know, where does the timetable sit?
Well, the timetable should be fixed at the very beginning of the case. So that's the importance of having a CMC or a procedural hearing, whatever we call it, at the beginning of the arbitration. It has to be complied with. If a party is seeking a prolongation, an extension to submit, it should ask leave from the arbitral tribunal. If the arbitral tribunal is convinced it would grant this extension, but it's the role of the arbitral tribunal to ensure that there are no abuse of process from a party. If a party fails to submit timely, then it would lose its right to submit. There is, under the different institutional rules, there is a sanction for that if a party completely fails to abide by the procedural timetable. So the procedural timetable is flexible. It can be extended, but I think an experienced tribunal should make sure that there is no abuse of process and the principle of celerity of arbitration is not compromised. So I think that is the answer. Perhaps what the attendee means by inserting the procedural calendar into the arbitration agreement, perhaps the person means the terms of reference. That can be the only justification, but it's the timetable is not in the terms of reference, it is in the first procedural order.
Yes, absolutely. One last question before we finish up. Thank you to Ali Sidoratio for the question. When should an arbitrator recuse themselves from continuing their office after their appointment? So circumstances in which an arbitrator may wish to recuse themselves from the tribunal. Dr. Ismail Assad, who would you like to take this one?
I can answer quickly, and I think Dr. Ismail also can add more from his experience. I think there are various circumstances where an arbitrator can, from his position, first of all, if he found that he's conflicted and he couldn't know this before his appointment, that if he found, for example, that there is something fishy or there's an issue in this arbitration and he need to step down. This is one of the, as well as conflict matters. If he found, I think that there is no jurisdictions and that I have seen a case before, and it has been written in some books where this one of the arbitrators found that there is something actually fishy and he stepped down, but the remaining of the tribunal refused to step down, so he may be stepping down. If he unwell and he felt that he will not be able to fulfill the requirements of being barred from the tribunal, this is what I'm thinking of now. I think also Dr. Ismail can add more to these reasons.
So I think the question is, thank you, Dr. Engineer Saad. I think the question is when an arbitrator can resign rather than when an arbitrator is recused, because recused, it means that the arbitrator is challenged for lack of impartiality or independence. But here, I think the question is when an arbitrator can voluntarily resign. If an arbitrator wishes to resign, I think it should be done at the very beginning of the case. If there are reasons, or compelling reasons to resign, it must be done at the beginning of the case in order not to waste time and of the parties. There is also, we have talked about dilatory tactics from the parties, but unfortunately there are dilatory resignations or tactical resignations that are made by arbitrators. There is a very, I think, very good decision of the Cairo Court of Appeal when an arbitrator resigns right before the signing of the award. It is not considered as a resignation. The Cairo Court of Appeal found that if an arbitrator, after reading the award, decides to resign, it means that the arbitrator did not accept the outcome of the award, and it's simply a dissenting arbitrator. It is not an arbitrator that is resigning. I think this is a very good decision of the Cairo Court of Appeal. So to say it's very bad that an arbitrator resigns during the deliberation because simply he's not happy with the outcome. If an arbitrator is not happy with the outcome, he can just draft a dissenting opinion objectively and in an impartial way.
Yes, absolutely. Run slightly. There are other issues that I think maybe apologies, there's a connection issue. I hope you can hear me. I apologize for the connection issues we've had. I think these are the after effects of the bad weather last week in Dubai. So I'm sorry for that. So just to conclude, thank you very, very much, Engineer Saad, for the fantastic discussion. There are various other questions that go to topics that we may want to discuss on another seminar, which go to other issues that we haven't talked about today. Thank you to everyone who joined and attended, and especially to those who asked questions. So of course, get in touch with us after the session. And thank you very much again to Dr. Ismail, to Saad, and to the CIR, both Qatar and Egypt branches, for inviting me for this excellent session. I hope this was useful and look forward to the next opportunity. Thank you.
Thank you very much, Antonia, for your excellent moderation of this session and the excellent script that you have prepared. It was a very good session thanks to your efforts. I'm also very thankful to Engineer Saad Hijazi for his excellent participation and his insights and his opinions today. And I would like to also pay tribute to him for his efforts within the CIR, and I encourage the members of the CIR not to vote to a particular candidate, but there are candidates to become trustees, and I really encourage the members of the CIR Egypt and other members of CIR in the region to actively participate in the voting process and to elect the trustees that they believe would be fit for the position.
Thank you,
hope to see Antonia and Saad in other occasions here in Egypt and with CIR or even with Corsica, hopefully very soon. Thank you so much, and thank you for the participants for the time that you have allocated to us and for following these useful discussions.
Thank you, Dr. Ismail.
I want to thank the Corsica team, Engineer Yahya, and all who worked for this.
Thank you so much, Dr. Ismail, for your hospitality, and Engineer Yahya again for the hosting, and the whole team, like Shireen and Corsica team, Antonia for the amazing moderating, and also our interpreters, Dean and Mustafa, and all our attendees. And thank you so much. And hopefully we can make this more and more. This is not the first cooperation between the CIR, Qatar, and Egypt. I think this is the third or the fourth one, and hopefully more is coming on the channel. And thank you so much, Dr. Ismail and Antonia.
Welcome. You're welcome. Thank you.
Thank you again.